Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
You especially won't go to court if it's bullshit charges because you get them thrown out.
I was kicked back, taking it easy.
By gosh, go down and fight them. By gosh, make them work for it. In front of the Walmart.
Welcome back. Welcome back from lunch. Hope you had a good one. Sorry, it took a little bit longer, but
break for lunch,
just had lunch. Just had lunch. Oh. Let's see. Kids cooked some frozen fish sticks for me as well. Okay, I was looking for this. The hearing was canceled. BK's hearing. Sorry, I'm busy typing. I'll be right back. Okay, so the latest we've got, I'm seeing this from Heavenly Stars on Heaven Stars 6 on Twitter. Order vacating and rescheduling hearing dates and opening some hearings to the public. Let's see if I can get a better copy than what she has here. Motion to temporarily seal exhibits of state's second supplemental response to defendant's fourth motion to compel discovery and state's supplemental response to defendant's fifth motion to compel discovery pending hearing. Looks like we've got some juicy stuff to read really quickly in the BK case. So welcome back from lunch. We have to welcome, first of all, nope, here we go. There we go. Of course, it's not working. Try this again. And again. There it is. Neezy69, welcome. First in chat this afternoon. Congratulations, Neezy. You have done this before, I believe. You've got a prior record, but you have once again won the internet with being first in chat. So we're going to send it to you to internet ownership. You're responsible for fixing everything connected to the internet for the rest of the day. So go ahead and just get on that, and we'll be most appreciative. Let's see. Why do I always get mood commercials when RA starts to stream? Do you Google Recovery Addict right before then? Because I always get like some self-help and counseling stuff when I Google myself. Boy, do we have kind of incoming spice in KR. Lee, we do. Definitely do. I'm trying to see if I can get this latest. In the BK case, we're waiting for a couple things. Have you heard of the Micah Miller? Oh, my goodness. Yes. JP down in South Carolina. I've heard rumors that there's an investigation still going on. We covered the release of basically the autopsy sort of thing, the coroner's report, I think was what it was. We covered the release of that for Micah, and it's tragic. It's terrible. But now there's more things happening. More things are coming to light, and issues and past occurrences and things that a lot of people are bringing out there. Somebody needs to dig into that a little further than I can. Last I heard, he was threatening legal action against anybody who said anything. So I have no desire to wade in right there right now. But if it becomes an actual case, then of course we could do something different. Let's see. We're going to jump over here to the Idaho cases of interest and scroll down until we get to BK. There's Daybell. That's a different one. Slowly, there's Daybell. And here is Kohberger. All right. The latest on this one. A couple documents to read. First of all, let's read the one about order vacating and rescheduling the hearing dates, because that was supposed to happen here this afternoon. The court, I can actually let you read these as well at the same time. That would be fun. Okay. A little bit bigger and go to camera 3. All right, I'm almost there. Sorry, lots of things are happening. First of all, Chris H. Just noticed I'm here for 1 full year. Look at that. Orange Courthouse, Chris. Thank you very much. Congratulations. That's a major accomplishment. Happy birthday, channel membership birthday to you. Thank you, Chris. Quick little read here. The court orders the following. Based on the agreement of the parties, the hearing scheduled for May 14th, that's today, at 1:30 p.m., for defendants' 4th and 5th motions to compel is vacated. This will allow both parties and the court additional time to review the information that was submitted by the parties between May 7th and May 10th. Oh, motion to compel, suddenly the parties delivered something. So it looks like just filing the motion was enough. Defendant 4th and 5th motions to compel will be heard on May 30th. So we've got a 2 weeks delay. At 10 a.m., after reviewing the submissions of the parties filed May 7th and May 10th, the court has determined that the hearing will be open to the public. Yes. Thus, the court's May 2nd, 2024 order granting the state's motion to close May 14th hearing is withdrawn. Thank you. If during the hearing issues arise that need to be addressed in a sealed proceeding, the court will clear the courtroom and discontinue the live stream of the proceedings on the court's YouTube channel. On May 23rd at 2:30 p.m., the defense will call a witness to testify. The testimony will relate to the defendant's 4th and 5th motions to compel. Because the witness is unavailable to testify on May 30th, the witness's testimony will take place on May 23rd. The hearing will be open to the public. However, if during the hearing issues arise that must be addressed in a sealed proceeding, the court will clear the courtroom and discontinue the live stream of the proceeding on the court's YouTube channel. Based on the agreements of the parties, the hearing scheduled for May 16th, in 2 days from now, at 3 p.m. for the IGG portion of the defendant's 5th motion to compel is vacated and reset for May 30th at 1:30 p.m. So everything got pushed out 2 weeks. This portion of the hearing will include arguments on the defendant's motion to allow defense investigators to review IGG materials and defendant's motion to unseal parts of IGG materials. At this juncture, the hearing will be sealed, as stipulated by the parties. In the event that the parties determine the hearing can be open to the public, the parties must file a stipulation to open the hearing no later than May 24th, 2020 to provide adequate notice to the victims' families. Although no hearing is set for May 31st, 2024, the court will reserve space on its calendar beginning at 10 a.m. that morning if additional time is needed to complete the hearing on defendants' motions to compel, including the portions pertaining to IGG information. This was filed by the court last night. So, what that means, no hearing today for Bryan Kohberger. Apparently, in the last, week, something has been turned over between the parties, probably from the state to the defense, is my guess. Because those items were turned over, the defense says, we'd like some more time to make sure the stuff we've got matches what we were asking for. Anybody know what cases we're talking about now? This is the Bryan Kohberger case. Bryan Kohberger, the Idaho 4, the 4 college students that were killed apparently with a knife, allegedly by Bryan Kohberger while they slept. But there was going to be a hearing today. There are a couple big things still coming up in this case, right? So if we go back to the upcoming schedule, now that we've got a couple moved here, we're going to change this one to the 30th. The motion to compel, possibly. And it's going to be open to public. Add this to our calendar. Possibly a May 31st. Let me insert this one as well. Reserve the date. Okay, so where we are, May 7th was the deadline for disclosing witness lists and exhibits. May 13th was the response from the state. It was supposed to be today, was open hearing to the public. That might be closed during it, but turns out that's going to be pushed to the 30th. The 31st, we might have something. The thing that was going to happen on the 16th is now pushed to the 30th. That means that June 27th, we've got a full day schedule starting at 10 a.m. in this case. That is the venue hearing. This is when the defense is going to argue for having the case moved. And guess what? Spoiler alert, it's getting moved. It's getting moved. This is going to happen. It's just procedure we're jumping through right now. We're jumping through the hoops to make that happen. But it's getting moved. 99% of the chance it's going to get moved to Boise. It's going to go to Ada County instead of in Latah County. But that's going to happen June 27th. I'm not sure if the judge will make the ruling then, but they'll have the hearing on it. And then you have, May 31st was the deadline for briefs about the venue. So right before them, state response, state reply. So June 27th. So when it comes to the venue, May 31st, the defense needs to provide information to the state about their argument for change of venue. June 14th is the deadline for the state to respond to that. June 20th is the deadline for the defense to respond to the state's response to their motion to move the venue. And then June 27th is the hearing. Once this goes to trial, how long is it expected to last? 14 weeks, something like that. It's forever. It is forever and forever and forever. Currently, I'll put this out there, the tentative date that the judge would like to see, which does not mean that's when it's going to happen, but the judge would like to see, and they're sort of pushing towards that schedule, is March of next year. So we're basically about 10 months away. I don't think that date's going to hold. It's probably going to push to be later in the summer or later in the year. But we'll see. So that's the latest from this one. Let's go back to let's close this one. Let's see what our other document was. Motion to temporarily seal supplemental response. Motion to seal exhibits. Okay, let's bring this one over. There's one, and let me grab one more. Okay, let's read this one first. The motion to temporarily seal exhibits is right here. When they seal it, that basically means it's we can't see it. It's not open to the public. It has not been presented yet in court. Once it gets shown in court, then it'll all come out. But until then, this is the motion to temporarily seal exhibits of state's supplemental response to defendant's fourth motion to compel discovery and state's supplemental response to defendant's fifth motion to compel discovery. Comes now the state of Idaho, by and through Latah County prosecuting attorney, and hereby moves the court, pursuant to Idaho law, for a temporary order sealing the exhibits, Exhibit 1 of state supplemental response and state supplemental response herein, because the release would interfere with enforcement proceedings, deprive a person of a right to a fair trial or an impartial adjudication. Oh, look, there are two twos. Do you guys see that? 1, it would interfere with enforcement proceedings. 2, it would deprive the person of a right to a fair trial or an impartial adjudication. Also 2, it would constitute an unwarranted invasion of personal privacy. It's like 2.5, I guess. 3, it would disclose the identity of a confidential source, and or 4, disclose the investigative techniques and procedures. The undersigned seek this protection pending a hearing on the matter, wherefore the state respectfully prays that the court seal from public disclosure Exhibits 1 of state supplemental response to defendant's fourth motion to compel discovery and state supplemental response to defendant's fifth motion to compel discovery. Herein, under the provisions of Idaho Court Administrative Rule, respectfully submitted, Ashley Jennings, Senior Deputy Prosecutor. That's one of them. And now let's go back to the other one, which is right here. This is the motion to temporarily seal supplemental response to defendant's fourth and response to fifth motion to compel motion to limit scope of testimony. Comes now the state of Idaho by and through Latah County Prosecuting Attorney, and hereby moves the court pursuant to Idaho law for a temporary order sealing supplemental response to defendant's fourth and response to fifth motions to compel and motion to limit scope of testimony herein because release or disclosure would, spoiler alert, same things, interfere with enforcement proceedings, 1. 2, deprive a person of a right to a fair trial or an impartial adjudication. Also 2, hey, guess who copied and pasted? Guess who has the copy-paste function just down? It's Idaho, by the way. 2, constitute an unwarranted invasion of personal privacy. 3, disclose the identity of a confidential source. And or disclose investigative techniques and procedures. That means, guess what? These 5, well, there are 5 things, even though there counts to 4. Those are the 4 exceptions. This is why we can close a hearing, right? And it does one of those things. Not necessarily all of them. It could do more than one, but one of them is enough to close it. The undersigned seek this protection pending the hearing on the matter, wherefore the state respectively prays that the court seal from public disclosure the supplemental response to the defendant's fourth and response to fifth motions to compel the motion and motion to limit scope of testimony herein under the provisions of Idaho Court Administrative Rule. Signed, William W. Thompson, prosecuting attorney. That's Santa Claus, the prosecutor. It's not really Santa Claus, but he has a big white beard. So that happened. That's the latest. Defendant's motion to the states, let's see. When was this one filed? Wait for it. That was the 10th of May. Trying to see if there's anything. Okay. We have this one more document that was filed on the 10th of May since we last were there. Oh my goodness. Well, we've got a few things to talk about today. It's really exciting. This comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby submits the following response to the state's motion to limit testimony filed May 10th. In the state's motion, the state contends that the affidavit of probable cause is irrelevant to this stage. That's in state's motion at 4. The state cites no authority for this claim. Mr. Kohberger has the ability to challenge the probable cause affidavits in this manner that were used to procure warrants. See what he's trying to do? If he can challenge the probable cause, then the warrant would possibly be invalid. And if the warrant is invalid, anything they find subsequent to that warrant becomes fruit of the poisonous tree, and ta-da, just like that. No evidence. Becomes a totally different case if there's no evidence, right? So that's why he's pursuing this. He wants to pursue these, the probable cause affidavit. Let's see. There was a case law finding the informer's reliability a relevant issue as it related to probable cause for a wiretap. Idaho, finding the informer's reliability a relevant issue as it related to probable cause for a search, and finding field performance of drug dog improperly discoverable as relevant to probable cause inquiry. Okay, the finding of an indictment does not preclude a defendant from seeking to gain through discovery information irrelevant to the probable cause provided to the court. They want this information. They want to know, how did you come up with this probable cause affidavit? Where did you get that information? How valid was it? Was it incorrect? Was it wrong? Did it have incorrect data in it? Susie says here, and Top Mark, my favorite hangouts. Awesome, Susie. That Top Mark case is a wild one. It's crazy. That's the Chad Daybell thing, which right now is in break, as you can see right here, just in break. But so that's the latest from Bryan Kohberger. Now we want to do just a quick check here on trying to see if there's some more documents in the Corey Richens case. Those are my tail lights. I haven't ordered those yet. Let's see. Let's see. Let's see. This is from KPCW, Park City, Heber, Summit, Wasatch Counties. Listen like a local. They report new documents show Summit County deputies found white pills at Richens' home. Separate filings claim fentanyl pills the Corey Richens allegedly purchased in February 2023 were light blue-green. They found white pills. Who's Corey Richens, you say? Who's Corey Richens? Corey Richens is a Camas mother. She lives in Utah, in Summit County. Mother of 3 who authorities say fatally poisoned her husband, Eric Richens, then wrote a children's book about grieving. Yes, she fatally poisoned her husband, according to prosecutors, and then wrote a children's book about grieving for her kids. Called something like Are You Still With Me or something like that. Are You With Me? Went on a national book tour. About that. Let's see, what other documents? They did find some hydrocodone pills that were prescribed to Corey. They found the drugs in Eric's system, but it was prescribed to Corey. Buttercup and I love watching your channel. You are the GOAT. Roof, roof. Thank you, Rebecca. Appreciate it. Congratulations on 16 months, too. That's awesome. Say hi to Buttercup from me. Kimbers, Ohio, also a member for 13 months. Time flies when you're having fun. Thank you, Kimbers. It seems like just yesterday you had a blue courthouse, right? Whatever happened to Sarah Boone? Is she ever going to trial? We will check. Today's a great day to do that. Let me do a quick Google search. Orange County, Florida, court records, clerk of court. Do a record search. Hello, it's me again. I'm searching for Sarah Boone, and I'm not a robot. Latest we have on that case for Sarah Boone is that there's a status hearing scheduled for 6/7 of 2024, which means next month, minus a week. So about 3-4 weeks away. Just looking, no letters. She must like her attorney. I think this is the longest she's had an attorney without writing a letter. Can Greg and Nick respond to the defense motion for sanctions, or is the first motion they did enough? It's probably enough right now, but they also could respond if they brought something up. If there was something that was brought up in the defense that they felt needs a response, I'm sure they're able to. Will you be at CrimeCon? I would love to be there. I have not done anything to make that happen, other than I reached out to them and said, hey, they said, apply here to get free tickets if you're a creator. And I did. And they said, thanks, but no thanks. So, fine. That's where we left it. I'd love to go, but I just haven't planned it in my schedule. Or bought tickets. Lenova gifted 10 Recovery Addict memberships. 10! Lenova, thank you very much. Look at those wonderful people who got the gifts. Candace Hoff, Annie Marie, Wendy Alexander, Gladys Epps, All About Eve, Victory Peniel, Christy, Sonia Polly, Marilyn Miller, and Carol Racine. Congratulations, and thank you, Lenova, for your generous gift. I might. CrimeCon is not that far away from me. I mean, I could drive there in a day, plus a little bit. It's a long drive. It's less than driving to Florida. We drove to Florida in a day, so it might be a possibility. I'd like to get that. I'd like to go. There's some good people who are going to be there. I'd like to meet. All right, so nothing on Sarah Boone as of just right now. Let's see, we should have me just check this. This is May 14th. Corey Richens' hearing is tomorrow, 9 a.m. Wednesday. That's a preliminary hearing. Hopefully we should get a date tomorrow on the Corey Richens trial. What do your non-attorney guts tell you? Non-attorney guts. Sanctions or no sanctions? Yes, I say sanctions. I think there's enough. There's enough there. Mary M., we're not going to catch up on Karen Reed, unfortunately. Brandy has the live feed on that, and she's doing a great job. I don't want to compete with her directly. We share a lot of the same audience, and she's just done so much homework on that. I don't think it would be nice or fair or kind of me to live stream the live feed and compete with her when she's put so much effort into that. Karen Reed Trail is on fire tomorrow at 8. Yes, it's gonna be great. Tess says, whoever will be there, come find me. I'll be in a blind crime T-shirt. All right, that'd be awesome, Tess. If I can show up there, it would be wonderful. We'll check and see. Oh, somebody's calling in. Might be. Hang on, guys. Hello. Hello.
This is Ellen with your local electric utility. How are you doing today?
I'm doing good. Hello?
You may not be eligible to receive 15% deduction on your electric bill. If you would like to talk with account representative and claim to reduce your rate, please say yes.
I'd be willing to talk to them.
Bye.
An account representative. The account representative. Let me just say, they want me to say yes. They want me to say yes. Why? Because there are some things that they can record you saying, and then they can charge you things. Yeah, they can charge you things. And just by saying yes to them is all they need. That's all they need. So I was not going to say that word for them. They hung up on me because I wouldn't say the word yes. That's what they wanted. All right. Can they record your yes off this stream? They could, but it takes a little more work. If there's only a place to get Recovery Addict saying yes like 10 seconds ago. I got in the habit of answering phone calls. I used to be tech support. I joke that we like to give away the internet. You have to answer everybody's calls. I used to be tech support where I was required to answer every call that came to me because people would call me from all over the country and from military, wherever, and need something addressed and need something fixed or checked on. And I was on call 24/7. And so I got in the habit of answering the phone all the time. I haven't looked at that yet. I did watch some of the other stuff out there about that same topic. Mostly I just ate lunch, Angela, because that's what lunch was for. I didn't do a lot of homework during that. You were a customer service representative? No, I was like a level 2 or level 3 tech. They called me an engineer. I was high enough that I was an engineer. True Crime Ranch, it would be awesome. It would be awesome if we can all meet up there. It would. There are so many people I want to meet that are going. That's the only reason I want. Honestly, I'm not big for sitting there and listening to people talk. I'm sorry. I don't do well just listening to seminars and listening to presentations. I'm too active. My brain's going 100 miles an hour. It's a good thing I've got like 6 different computers to play with here, because just sitting here, I would get bored out of my mind. I guess that's the ADD in me coming out. Let's see. Welcome back, Candace. There you are. We've got you. I'm True Crime Ranch and forgot to change accounts. So True Crime Ranch and I would both like to meet you. Both of you. Wow. Possibly on the same day. That would be great. Thurston District 2. I was actually looking at this earlier. You say
really complicated for me personally. So.
I understand that.
I've got it pulled up right now.
We agree on that. But again, we're going to have to wind up here today. And then again, I'm going to say this again. I'll probably say it a few more times. You need to speak with your attorney to get you set up for an evaluation. And it sounds like there might be one imminent. And you can go.
Yeah,
ahead and
we're going to back up just
court.
a little bit. We're going to back up and see what's up with this one. Let's go right about here. See what's up with the last 20 or so minutes. Let's see what's up in Thurston County this afternoon. Ivan.
All right. Thurston County District Court is back in session.
You can be seated.
This is not a good idea, Ivan. Or
Ms.
I will come
Kamari?
visit you in jail.
Your Honor, I'm ready with Amanda Payton on the 9:30 calendar.
We're at the
What's
morgue.
happening today?
Change of plea.
So, Ms., you are Amanda Payton.
Yes, sir.
I'm looking at a statement of defendant on plea of guilty, which tells me you're pleading guilty to theft. Is that your understanding of what's happening?
Yes, sir.
Maximum you can receive for this is 364 days in jail and a $5,000 fine. Do you understand that?
Yes, sir.
You also understand as a result of your plea, or you're giving up all the rights contained in paragraph 5 of your plea form.
Yes, sir.
City's going to recommend 364 days in jail with 363 suspended, credit for 1 day served. Doesn't say a jurisdiction period, just 12 or 24 months there, Mr. Sharp.
It'd be 24, Your Honor.
For the next 2 years, don't have any criminal law violations and stay out of Safeway and Lacey. Do you understand that?
Yes, sir.
Oh, Safeway.
Do you understand I'm not required to follow that recommendation?
Or Safeway in Lacey.
Yes, sir.
Anybody make any threats or promises other than what's contained in the plea recommendation to get you to plead guilty?
No, sir.
Paragraph 11 of your plea form says, on or about January 29th, 2024, in the city of Lacey, you unlawfully took property from Safeway. Is that true?
Yes, sir.
And did you review this whole plea form with your attorney?
I did.
Any questions about any of it?
No, sir.
I'll accept your plea. Enter a finding of guilty to
It's like a
theft.
grocery
Enter
store, I
finding the plea was made knowingly and voluntarily. We'll proceed with sentencing. Mr. Sharp, anything further from the city?
No, Your Honor. Thank you.
Ms. Kamari,
Your Honor, I request you follow the agreed upon recommendation.
anything you'd like to say at this time, ma'am?
Nope. Just that I appreciate the recommendation.
364 days in jail with 363 suspended, credit for 1 day served. There'll be $43 in court costs. Don't have any criminal law violations. Stay out of Safeway in Lacey.
Okay. Thank you.
I'm just going to say, I know there's more than one Safeway in Lacey. I would just stay out of all of them.
Yeah, I will.
And
No, it's just
that'll
Walmart
be
for you,
conditions
man.
will be case for the next 2 years. You can get a copy of this judgment and sentence off the district court website if you want. Otherwise,
Okay.
that's it for today. You're free to go.
Thank you.
You're welcome. Ms. Kamari,
Your Honor, nothing further at this time. Mr. Swenson has some clients ready.
Mr. Swenson,
Swenson, my friend.
Yes, Your Honor. Charlene Bledsoe, present on Zoom.
Wake up, Charlene. Wake up. It's time.
what time is she scheduled to be here?
At 10 or 10:30?
That was 10.
10.
She's asleep. Oh, can't be bothered. Judge, wake me when it's my turn, okay? Go ahead, lawyer. You take care of it. That's what I pay you for.
What's happening today here, Mr. Swenson?
Entry of a stipulated order of continuance, Your Honor.
Tell you what, Charlene, you just get comfortable, and when you're good and ready, we'll start. The judge is incredulous. He's like, what are you doing? What are you doing? I guess you straightened the camera. That's worth something.
So, Ms. Bledsoe, I'm looking at a statement of defendant or I'm looking at an agreement between you and the city in which you have agreed to continue this matter without a finding for a period of 12 months. So, on the condition that you don't have any criminal law violations, don't possess a firearm or other deadly weapon, and comply with any existing no contact order. Do you understand that?
Yes.
Say that again, please, ma'am.
Yes, I do.
Okay. And you understand if you comply with those conditions at the end of 12 months, this will be dismissed. But if you fail on any of those conditions, you'll be brought back before the court. Your guilt or innocence will be determined by a reading of the police report. Do you understand that?
Yeah.
So you're giving up your right to a trial, but you're getting the opportunity to have this dismissed so long as you comply with those conditions. Did you review this with your attorney there, Mr. Swenson?
Yes, I did.
Do you have any questions at all about what's happening?
No.
Anything further from the city?
No, Your Honor. Thank you.
Mr. Swenson?
Thank you, Your Honor. I think this is a fair outcome. Ms. Bledsoe already completed an online anger management class that was provided to the city, so that's not listed as a condition.
It worked. She's not angry now.
But I think she won't have any trouble with the conditions as stated.
So there's still a no contact order in place, and so you need to continue to comply with that. Do you understand that, ma'am?
Yes.
Anything you'd like to say at this time?
No.
This case will be continued for 12 months. Don't have any criminal law violations. Don't possess a firearm or other deadly weapon. Maintain compliance with the existing no contact order, and that's going to remain in place till a judge says otherwise. Do you understand that?
Yes.
Good luck, ma'am. That's it for today. You're free to leave the Zoom call.
She's already gone. She was so over this.
Thank you, Your Honor.
You're welcome.
Next, I can call Wesley Guerin, present in person.
Wesley.
Mr. Guerin, you want to come up there? So this is on for a sanction hearing.
Sanctions.
That's right, Your Honor. And defense is going to request a brief set over. The reason being Mr. Guerin did provide or is going to provide a victims impact panel proof to the court today. He tried to get his assessment done yesterday, but had to reschedule due to insurance issues for May 24th. So I'm hoping to have a copy of that assessment before we proceed with the sanction hearing.
Okay, but you do have the victims impact panel?
Yes.
Okay, Mr. Sharp?
Sorry, Your Honor. Just a second. Just checking jabs.
Sorry, Your Honor. I'm busy turning my screen. Is it bright enough for you?
How many
Should I turn
copies
it
of
up a
that do
little
you
bit?
have?
Just one.
Okay. Did you have a copy? You have it already. I'm going to have you bring it up here so you can copy it.
No objection, Your Honor.
We're going to give you a new court date. Thank you, Ms. Ahmad.
I had done that assessment earlier, but I was going on Social Security. That's what the insurance was.
Okay.
Figured out.
Ooh, we have a Mohawk comb over beard combo in court. Did you guys see that? That's a look I have not seen in a long time.
Okay, this one can go back to you. And hang on just a minute. We're going to make a copy of that. I appreciate that from St. Pete's. We're going to make a copy of this of the victims impact panel. So that's been done. We'll keep that, give you your copy back. And then we're going to give you another court date so you can follow up on the eval there.
Okay. And
Before we do that,
court date, so this doesn't happen again, call.
You can zoom in if you wish. Yep.
Okay.
And then, do you still live in Peregrine Loop in Lacey?
Yes.
And then have you been getting text reminders of court dates?
Yes, I have.
Okay. When you get the notice, you should should give you instructions for how to zoom in. But you can do that if you want, or you can come by in person. Frankly, I always prefer the in-person court appearance, but that's just me. I think I'm in the minority around here, but that's it here for today. You're free to go.
Okay, thank you.
Oh, actually, don't go just yet. Let's give you, I'm just going to tell you what your court date is. We'll follow up with a written notice. 5 weeks or so.
put down 5 weeks.
My understanding at St. Pete's is I'm gonna sign the information sharing thing, so they'll.
Perfect. Great. We'll do June 18th at 9 a.m. And we'll print a copy of that to give you that too. Just stand by for a minute. You can go ahead and come on up and get that. Once you get that, you may go. And Mr. Swenson?
Thank you, Your Honor. I think we're ready on Johnny Brasino. If Mr. Sharp has had a chance to review the SOC.
Should be on his file now.
Johnny, come on down. I'm hoping this doesn't just disappear.
So you're here on a driving with license suspended in the 3rd degree, Mr. Brasino?
Yeah, that's correct.
It's not here.
Yeah, I'll check. Sometimes it bounces into the clerk folder. It did. 1 second, Your Honor.
All right. So in a minute, I'm going to get a form that's going to tell me that you're going to continue this matter without a finding for a period of time, subject to certain conditions. Is that your understanding of what's happening?
Yes, it is.
Should be there now, Your Honor.
Just refresh.
Those conditions, it'll be continued for 1 year. The conditions are basically don't have any criminal law violations and don't drive without license or insurance. And if you do that, at the end of the year, this will be dismissed. Do you understand that?
Yes, I do.
If you fail any of these conditions, though, you'll be brought back before the court. Your guilt or innocence will be determined by a reading of the police report. So what's happening is you're giving up your right to a trial, but you're getting the opportunity to get this dismissed so long as you comply with basically those two things. Don't drive without license or insurance or have any criminal law violations. Do you have any questions about what's happening?
No.
And you reviewed all this with your attorney there, Mr. Swenson?
Yeah, we spoke about it.
And then what's your license situation? Do you have it back?
Yeah, I got it back on the 10th, I believe.
Okay, perfect. I just can't. Great, then you should be in great shape. Just make sure you maintain insurance and maintain your license. Anything further you want to say?
No.
Mr. Sharp or Mr. Swenson, anything you were going to say?
No,
nothing here.
To ratify. Thank you.
All right. Nice job on getting your license back. This will be continued for 12 months. Don't drive without license or insurance. Don't have any criminal law violations. If you do those things, this will be dismissed in a year.
Cool. Thank you.
You're welcome. You may go. Mr. Swenson?
Michael Chai, I believe, is present in the courtroom, Your Honor.
Come on up. And this is on for a competency hearing?
That's my understanding, Your Honor. And there's no, it hasn't been done yet, but it likely could be done very soon, given what I know about the scheduling process going on in my office right now. So just ask for one more reset.
How far?
Probably 90 days.
Mr. Sharp?
No objection. I know Mr. Che's expressed frustration with how long it's taking before when he's been in court, so I'm glad to hear it's going to happen soon.
Yeah, go about 90 days. You're going to get a court date for August 13th, okay? We'll give you, you can write it if you want to, but we're going to give you a piece of paper with it on also.
Do I have a chance to say certain words?
Yes.
Just to add. Last time I was here, I recommended to Mrs. Kamira that the lawyers, she or his her crew recommended rather leave a text message with the name so I can receive the calls. I received certain calls, random numbers. There were certain number on the paper, but I had a problem detecting paper with the English on it. And
we can give you a court date right now. And then
I'm not finished.
What's that?
I'm not.
Yeah, I'm not completely understanding what you're telling me.
I'm not against you, but it feels like you have hostility toward my particular case.
Me?
Yes. If you have any information given beforehand, before I met you here, I know I did some action back there, but that I couldn't really. I wasn't able to explain. So I had to show by action, but if it offended you, I'm sorry. I want to apologize.
Was that a cat that
all
just
I
jumped on you?
needed, I want to say this, all I needed was
watch the replay.
Just time for interview, just welcoming, just doesn't have to be warm, just welcoming invitation, have some time and sit down and exchange some environmental or cultural background and give some time. And 2 years ago, I found out about my my disability that nobody really understands. Medically, phone calls ringing, I cannot speak to women in certain type because of my inverted chest, upper side. When I was young, under age of 5, those information was not revealed until about 2 years ago.
I think you need.
So I'm starting to understand, and the all the data or information or files I submitted to the court clerk's office. Have you received them?
I have not. Whether the clerk has received them or not, I don't know. I can tell you I have not reviewed them.
I submitted them last night and
last night
or so. And then, before the nights, I've submitted a lot of documents. But it seems like the clerk, some young clerk, she showed some behavior that she was hesitant to show you or reveal to the court.
Okay.
The files and texts I sent, but you need to verify if you're giving me time to if you need time to go over those materials. Is that the reason why you're giving me extended period of time?
No.
I don't need a lawyer. I can just openly openly reveal everything I had.
Okay.
I present to the court. I cannot go to trial.
Okay. Can I speak for a minute?
Yes.
Okay. So I'm going to do my best to try and explain to you where we are here. Okay. So first of all, you haven't offended me. I hope I haven't offended you. I certainly haven't meant to. You do have an attorney, and I can give you contact information for your attorney's office. Okay. The reason that you're here and why, these issues that you identified, the attorney has some concern about your ability to understand completely what's going on and help in your defense. So you need to be seen by a professional from Western State Hospital, and then you can talk with that person about all these issues. Someone who is a mental health expert, which I am not. And then they'll make an opinion as to where this case is going to be headed one way or the other. And so until that happens, I would recommend that you save those documents that you have and share them with your attorney or share them with...
those documents were lost during the process of delivering stuff from cops, from my mother's residence to to me separate when I separated. So cops are involved. The Lacey.
You need to, the person you need to communicate with this, all these issues wait, let me finish, please. You need to talk with your attorney about this, not with me. Involved on one side or the other and take a position. That's not my role. And Mr. Swenson, just a minute. Who's the attorney? Is it you or Ms.?
No, it's me, Your Honor. And if he could call my office or my cell phone, the court can give him the 503 number.
You have the number. No, the one, the letter.
The attorney's like, can you give him my burner phone?
Okay, you can go ahead
just
now.
the burner phone,
Okay, thank you.
the other.
So the whole reason, the whole package, the documents, papers, the status, citizenship, any documents, grades, college degree, certificates, other etc. documents, they were needed in order to achieve my academic goals, and I failed. I put about 23 years just being alone. Culturally, academically, I didn't ask much for help. I was alienated socially, mentally, physically, most of the time. Spent 23 years. After high school, I went to church, and then I needed some help, and God didn't respond properly. And anybody who's near God didn't respond to me properly. And if it has to do with some type of incident happened in high school, maybe violence, I can point that out. The past history in South Korea, they manipulated, or they set me up to make me downgrade violence. I was very reserved. I don't approach people because that's how I was raised in South Korea. In South Korea culture, someone who with a disability, they are trying to hide it somehow. So in order to not make a problem, I was trained and I was raised as not to approach the people. And then I came here with a lower grade because it was decided I'm going to come study abroad, and it was very competitive in high school and middle school. So I let my grades drop. I didn't care much. And there were also some type of strategic ways, some leadership. Some friends asked me to hang out on the street when test times are coming, and I've just flunked the test. So that's the condition I was given when I came here. And then there were some instant physical contact with some of the students, but it was not a bad. It was for some people, not consciously, not unconsciously, knowingly, not knowingly. But I think I'm a good person. If there is enough explanation or manual before anything happened, that could have prevent all those issues. And I don't want to point, or I don't want to hire a lawyer and point somebody or point the system, but that's just my personal cases here.
Okay.
So I don't need documents, but I'm thinking past, present, and future. But time, it didn't work very well for me. So I had to gone off back to South Korea about 6 years ago. And started.
So, Mr. Chai, again, I'm going to stop you.
I can take deportation.
Okay. You need to communicate with your attorney and with the professional from Western State Hospital about these things. I appreciate what you're saying. You have a lot you're dealing with. I get that. But I'm not the person you need to talk to about these things. It's with your attorney and with the medical professional from Western State Hospital. So I'm going to give, you're going to hang on just a second. You have your court date, right?
Yes.
Okay. I'm going to give you this also. This is an introduction. Ms. Ahmad will give that to you. It's an introduction letter to your attorney's office. I hand wrote in ink on the bottom your attorney's name, Mr. Swenson, and the phone number there. You need to speak with him about your case. You don't need to hire an attorney. An attorney's been appointed for you. You have one. It's that guy right there with the purple tie and the beard.
And the cat.
So you can communicate with him about these things.
Okay. Yes. One last thing. The 4 years this has been going on, and I I think I wasted enough time. I mean, you wasted also, everybody wasted here. First, I decided not to go to trial because I don't have a power. I don't have much ability to push the forward or to have a trust with anybody who I meet here. So I already spent 4 years and I cannot continue. I gotta somehow I need to get my mental exam in South Korea.
Okay.
And meet South Korean, not here, because I have a special condition here. I mean, it stacks up.
Okay. And I will say, unfortunately, since we're here, this is alleged to have happened here. It's got to happen here.
It's got to happen here.
The evaluation does, yes. So that is one thing that I can address. The evaluation needs to take place here.
I've gone to several institutions.
Okay. And again,
please, I'll do go back.
Okay. I don't know what you want me to tell you.
I need family support.
What's that?
But I need family support. I do have a family, biological family. But if I cannot, I need support from relatives in South Korea.
Right.
Sorry about time.
Okay. Well, I mean, again, there's nothing I can do about that. I can't send you back to South Korea. I can't. The only thing I can do is order an evaluation, which apparently has, whether that's been done by me or not, and that needs to happen here, and it will happen here. But again, when out of custodies take a lot of time.
Yeah, like I've been, ever since I come to the United States, I've been an orphan state. Even though I had a family, they have a different places to study and work. So we can initiate communications or conversation, but we don't really much understand each other. You would understand, but the thing is, sorry, it's my second language. English is my second language. I just blacked out, but the point is,
this would be a good time for the attorney to step in and say, I'll call you.
I've been an orphan state, and then any organization or any person who has a friend, family, or some type of multiple of more than one person or multiple of two, they are not working. They are not helping me.
Okay.
So, in order to help me, you need to meet what I say. I need to go back as soon as possible and get treatment in South Korea.
Okay. That's not something that may need to happen. And again, we're going to wind this up here because we have to be done by noon, and we have a lot of cases that are set here. In order to go back to South Korea, that may need to happen. That may help you. I'm just saying I can't facilitate that. There's nothing I can do about that. I just can't. And you're not wasting our time. I do want to address that. This is our job. It's important for us to be here and do that. Again, I'm going to refer you back to your attorney. Contact that individual there, and then you can talk with him and get the evaluation.
What was this paper about? Is his organization?
Yes.
Just the number. His number.
Okay, but let me ask you.
No. I mean, okay. You can ask a question, but and then I'll give you an answer, and then we'll conclude here. Go ahead.
Were there any cases like this? You have experience what I say? Do you understand what I say?
Some, but not all. But I will say this, every case is different. And so when somebody asks me, hey, have you ever had a case like this before? I've had that charge before, but everyone's different. So there's not, you don't put people into groups and all that sort of stuff. And so that's that. You asked a question. Simple. I gave you an answer. What's that?
My case would be simple to me. It is kind of simple and minor to me and to others, but in deep down, it's really, really complicated for me personally. So.
I understand that, and we agree on that. But again, we're going to have to wind up here today. And then again, I'm going to say this again. I'll probably say it a few more times. You need to speak with your attorney to get you set up for an evaluation. And it sounds like there might be one imminent. And you can go ahead and step back into the courtroom there, Ms. And that'll conclude the hearing here for today.
Cops involvement. I let go of those documents.
I can't speak to that. I don't know anything about that. I don't know what happened. And again, you need to speak with your attorney about that. I don't know what the documents are. I don't know where they are. I don't know who took them. I don't know anything about police involvement. I can't speak to that. I don't know anything about it.
Well, then what is the issue here?
Okay. The issue is
don't know
you
anything
need to
about
get
my
evaluated
case. Why am
by
I here?
an individual from Western State Hospital. Your charge is violation of a no contact order. And again, we need to, I don't know that I can explain it any simpler than that. And again, we need to conclude this. We have to be done by noon today. And again, I want to give everybody the time they need, but I feel like we're kind of going in circles now. But again, you need to communicate with your attorney and then get that evaluation set up. And hopefully that'll help you. That will get you in a position where you need to be.
I've done it before.
Okay. You're going to have to do it again. If you have done in other cases, you're going to have to do it again. Okay. And you can step back into the courtroom and then we're going to be done for today.
All I asked was minimum human rights. I'm not like this.
Okay.
I mean, I'm not like what's written on police report.
Okay.
Lies. Maybe it's a different system, but
okay. You need to step back into the courtroom, please.
Yes, sir. Thank you.
Language barrier, definitely a problem.
Yeah, before we call another case, I'll jump in to say I think Ms. Kamiri and Ms. Lee and Ms. Parlett all need a breakout room, and that might take a few minutes. So maybe we should.
Okay. Candace, you take them. Okay, thank you. Mr. Swenson, who do you wish to call next?
He's still thinking about that last case.
Your Honor, I don't think I'm ready on anything right now. We can start with the FTAs.
Okay, no, there's some people in court here. Let's figure out who they're at and what that you in the black, is that a Spanish-speaking individual, Ms. Ahumada?
On the first row is Ms. Maria Clara Moreno Ramirez, this lady.
Maria Moreno Ramirez? Okay. And then whose client is that, Mr. Swenson?
That's mine, Your Honor. I'm not ready to address that, however.
Okay, and then who's in the second row?
¿Cómo se llama usted?
No. Ms. Parlett, someone's going to come and take you to a breakout room with the interpreter and Ms. Kamiri. So just wait for a moment.
Okay, so Pascual Hernandez is present as well, Your Honor.
I'm sorry?
Pascual Hernandez. He's
right, and then
number 2.
Pascual Hernandez is here also. Do you know whose client is that?
Yeah, that's mine also. I think.
Okay. And hang on just a minute. There's one other. You told me your name, and I can't. What time are you scheduled to be here?
I don't know what happened.
Mr. Peak is here also on a DUI.
And that is Ms. Kamiri's.
Is she ready?
You could please give me a call, Your Honor.
Okay. You have the phone number? What number do you want? Are you together with Mr. Peak?
Yes, sir.
Okay, great. Well, what number do you wish to have him call, Ms. Kamiri?
253.
I'm not going to give out her phone number. 867-5309.
Okay. Then I'll step off and give you a chance to, I want to tell you folks again, it's now 11:23. I actually do need to be done at noon today because I have a meeting at noon that I'm going to need to make. So I'll come back in a few minutes and then we'll go forward on these. All right.
Can we cover FTAs, Your Honor?
What's that?
Yes,
we can do that. But Mr. Peak needed the number again. Ms. Kamiri, what was that again?
25.
Was 867-5309.
So we can do FTAs there, Mr. Sharp.
Thank you, Your Honor.
BK got canceled, Allison.
I have a few 3-4 appearances.
What's that?
They canceled the
I
hearing.
have a few 3-4 appearances.
Okay, we'll run through these quick. Tell him Clevenger.
No, Your Honor. No information.
Requesting
Mr.
1,000
Sharp.
on each.
Say that again.
1,000 on each, Your Honor.
Warrant soliciting amount of 1,000 cash or bond in each case. Anthony Frankson.
Your Honor, the only information I have today is I did notice that competency proceedings were initiated again in Superior Court. We had done a competency evaluation on Mr. Frankson while he was in custody. He was found competent. He has appeared at all of his hearings since then on Zoom. I'd ask the court to consider noting the FTA, but not issuing a warrant at this time. I don't see any other active warrants, and I can try to reach out to his parents.
I could have saved you the breath. That's what the city was going to request to you.
Okay, so note the FTA and reset it.
Yeah.
Yes, please.
We'll strike the trial dates. I remember this case. Strike the trial dates. We'll reset it for pretrial with notice to mail. Dennis Kerwin.
Requesting $2,500 on each, Your Honor. We have an arraignment. I'm not sure if probable cause was established yet or not. And I guess I would just ask to reset the arraignment rather than bog us down with establishing probable cause if there's not a stipulation.
We can reset the arraignment on an arraignment calendar. 2,500 will issue on the other two.
Thank you.
Todd Loving.
No information.
Requesting 1,000.
Warrant to issue amount of 1,000 cash or bond. Estrella Paz Bjorkas.
Your Honor, she's authorized me to appear on behalf, but requesting a pretrial be set for July 9th.
Our court date set right now on that?
Yeah, no objection except for speedy.
I'll have to check. I think it was my understanding July 9th still keeps us within speedy.
It's right to a speedy trial is what they're talking
Right
about.
now.
She hasn't waived it. Meaning they have to take her to court.
So speedy trial, we're running 90 days from April 23rd, according to the docket, which would take us to middle of July. So we could just set a trial date near the end of the 90 days from there if you want to, with confirmation and trial date. And if you get something in place before then, you can do that.
Yes, Your Honor.
So all the confirmation still, all the contact information still the same?
Is the number you have ending in 2227?
So we'll set it for trial within 90 days of April 20, whatever that was, April 23rd.
Can we set
And since he was here,
for July 9th?
Sure, with subsequent trial dates, that's fine.
Middle ground. We read the documents on this one.
Confirmation and then set trial dates within
Today's
a
hearing
week.
and Thursday's
Melissa
got moved
Matthews.
to the 30th.
Your Honor, if we could get info on any 3-4s and other things where defense has an issue, I'd be happy to address FTAs on the remainder while they're in breakout rooms.
Okay. Well, we're almost done. Melissa Matthews?
No information, Your Honor.
Requesting 1,000.
Chad Thompson, 1,000 will issue.
No information, Your Honor.
Requesting 1,000.
1,000 will issue. Ricky Fuentes?
I believe he's held in King County on $5 million for a murder one charge, requesting 1,000 for failing to appear.
1,000. Amanda Zirek?
For murder one.
Requesting 5,000, 2 active warrants and rich warrant history.
Warrants to issue amount of 5,000 cash or bonds. And then Christopher Martinos?
Requesting $1,500. Look at the nature of the charge. He's got 1 active warrant elsewhere and 1 prior warrant on this case.
Warrant to issue in that amount. Jessica Bradley?
Your Honor.
1,000. Oh, sorry.
Well, I don't have information, but I was going to ask the court to not impose a warrant today. I don't see any other criminal history or warrant history. This is the first pretrial. I have a good phone number. I'll keep trying to hopefully reach.
Confirmation set for the confirmation set for June 4th with trial on June 12th and 13th. We can just leave those court dates set. And then if you get a hold of her, tell her if she doesn't appear then, a warrant will issue.
Understood.
Mr. Sharp, do you have any objection to that course of action?
Wondering if the court's noting the FTA for speedy purposes.
We can. We'll still leave the court date set though. Caleb Harless.
Requesting 2,000 each. There's an active warrant in Superior Court, has warrant history.
No information.
Warrant will issue. And then I see there's a Swahili interpreter for the 11 o'clock. Is it Samuel Gashira?
Samuel Gashira?
We're expecting Ms. Bowden at some point for that.
What's that? Wait, how much was the Harless warrant you were requesting? 1,500?
2,000 each, Your Honor.
Okay. And then Samuel Gashira is here.
Samuel Gashira, Yuko.
Oh, wait a minute. Okay, that you, Ms. Bowden?
Yes.
Okay. Can you adjust your camera so I can see more than your forehead, please? Thank you.
Beautiful. Good work.
Is that Mr. Gashira there with you?
Yes.
So, Ms. Bowden, what's happening today with this? So let the interpreter interpret, please.
Ngojea ni mtafsiri tafsiri tafadhali.
Yeah, we've reached a resolution.
Tumefika uamuzi.
I've emailed that to the clerk, Your Honor.
Nimetuma kwa barua pepe kwa koti.
Thank you.
Asante.
Kevin, good luck in your jury selection. Virginia, we're up in Washington, the city of Lacey, Washington. Thurston County.
You know who that John Gishoshi is?
No, I keep trying to page Miss Bowden's.
No, but there's I know, but there's another one next to it with the J on it. Yes?
Call this number with your fax machine.
Okay, just stand by for a minute, Mr. Peak. I'll get to you in a minute. When they're back on, we'll try it again.
Oh, there you are.
Is that the lawyer's office?
Okay, so
right now. Take the dog.
You're Samuel Gashira?
Wewe ni Samuel Gashira?
Yes.
Yes.
I've just been handed a document which tells me you and the city have agreed to continue the matter for a period of 2 years without a finding.
Na anasema kamepata karatasi ambayo wewe na upande wa sete wamekubaliana kuendelesha kesi kwa miaka miwili.
There's a number of conditions in place.
Kuna masharti ambayo yamewekwa.
Those conditions include a $240 monitoring fee.
Hizo masharti zinaenda hivi 240.
Don't consume any alcohol or have any controlled substances without a valid prescription.
Usikunywe pombe ama madawa mengine usipoandikiwa na daktari.
Don't refuse a breath test if one is requested of you.
Huwezi kataa kupumua kama ukiulizwa.
Stay out of bars and taverns.
Usiende kwenye mabaa ama matavern.
Don't have any new law violations.
Na usivunje sheria mara nyingine.
Don't drive with a BAC of 0.08 or higher.
Usiendeshe na kipimo cha pombe ambacho kiko juu ya 0.08.
And don't drive without license or insurance.
Na usiendeshe gari bila leseni ama insurance.
You're also to get a drug and alcohol evaluation and comply with whatever is recommended.
Alafu lazima utapata evaluation ya kuhusu mambo ya utumiaji wa pombe na madawa, na watakapokuambia ufuatilie vile watakwambia.
And attend a DUI Victims Impact Panel.
Na uende kwa video panel ya mambo ya DUI.
And you understand if you do all those things over the next 24 months,
na unaelewa ukikamilisha haya mambo yote kwa miezi 24,
this will be dismissed.
Hii itarushwa nje yote.
If on the other hand you fail on any of these conditions,
lakini japokuwa ukianguka kufanya haya mambo, jambo lolote kwa haya mambo yote,
you'll be brought back before the court.
Utarudishwa kotini.
And your guilt or innocence will be determined by a reading of the police report. Do you understand that?
Na sasa wakati huo watasoma tu polisi ya ripoti kusema kama uko na makosa ama hauna. Unaelewa hivyo?
And
yes.
So you're giving up your right to a trial.
Sasa kwa sasa haki yako ya kwenda kesi unaitupilia mbali.
But you're getting the opportunity to get this dismissed so long as you comply with all those conditions.
Lakini unapata nafasi kufanya hii kesi irushwe nje unapokuwa tu kama unafuata hayo masharti umepewa.
You should also understand that if this were to be revoked and a conviction enters,
na uelewe kwamba kama hii ikivunjwa na ukapatikana uko na makosa,
you would be subject to mandatory jail time of 1 or maybe 2 days.
Itakufanya utaweza enda jela kwa siku 1 ama 2.
Additional license implications, including ignition interlock and possible suspension.
Na mambo mengine yanahusiana na leseni yako, ile kuweka kitu cha kupumua na hata leseni ikaondolewa kwa muda.
Do you understand the consequences of not complying with what these conditions are?
Unaelewa vile kunaweza fanyika kama usipofuata haya masharti umepewa?
Yeah.
Yes.
Do you have any questions at all about what's happening here today?
Una swali lolote kuhusu ambazo jambo lolote linaendelea hapa leo? No.
Have you been evaluated yet or done a victim's impact panel yet?
Umeenda kufanya evaluation hiyo mambo ya pombe ama victim panel yoyote, umefanya kitu chochote kama hicho?
Your Honor, he has done his evaluation, his alcohol.
Okay, so go ahead.
School and victims panel. I forwarded it to the prosecutor. I will forward a copy to the court.
Ndio amefanya hiyo ya victim panel na evaluation na nitaitumia koti.
Did the evaluation require treatment or just the drug and alcohol information school?
Na mambo ya evaluation inahitaji aende matibabu ama ni tu shule ya kuhusu mambo ya pombe?
Drug and alcohol information school.
Mambo tu ya shule ya mambo ya kuhusiana na kuendesha gari kama mtu amelewa.
And that's been completed as well?
Na hiyo imefanywa?
Yes.
Ndio.
Fantastic.
Oh, hiyo ni mzuri.
Anything you'd like to say at this time, Mr. Gashira?
Mr. Gashira, kuna jambo lolote unataka kusema?
Hapana.
No.
And I can't remember whether I asked you to say anything or not, Mr. Sharp, did I? If you wish to say something, now's the time.
Sema kama ungetaka kusema yote useme sasa hivi.
I'll just say I know Ms. Bowden worked hard for her client on this case and City believes it's a fair outcome.
Najua amefanya kazi mzuri kwa hii kesi na imetokea tu vizuri.
Ms. Bowden?
I agree. I appreciate the offer from Mr. Sharp. My client did. He is proactive. He's gotten everything done. He's aware of the consequences. He's stands to have a great outcome.
Anasema nimefurahia kuhusu vile jambo tulikubaliana na amefanya mambo ambayo yametakikana na akifuata basi hili jambo litakuwa linamfaa sana.
And I'm confident he'll be successful.
Na ninaamini kwamba atafaulu haya.
Mr. Gashira, this will be continued without a finding for 24 months.
Hii kesi inaishwa kwa miezi 24.
Subject to the following conditions.
Na haya tu masharti yatawekwa.
Pay $240 monitoring fee.
Ulipe shilingi 240.
Don't have any criminal law violations.
Usivunje sheria tena.
Don't drive without license or insurance.
Usiendeshe gari bila leseni ama insurance.
Stay out of bars and taverns.
Usiende kwenye mabaa ama matavan.
Don't consume any alcohol or have any controlled substances without a valid prescription.
Usikunywe pombe ama ukakunywa dawa zozote bila ruhusa ya daktari.
Don't refuse a breath test if one is requested of you.
Kama ukiambiwa upumuze na polisi huwezi kataa.
And show proof of your evaluation, drug and alcohol information school, and victims impact panel.
Na uonyeshe proof kwamba umefanya ile evaluation na ile victim panel.
And I'll give you 30 days to get that in since it's already been completed.
Na napatia siku 30 uonyeshe haya kwa sababu ushayafanya.
Good luck going forward.
Nakutakia na heri ukiendelea mbele.
Thank you, Honor. Thank you, Mr. Sharp. Thank you, Mr. Interpreter.
Thank you. Asante sana. You want it. Thank you.
And you were all free to, Mr. Interpreter, is it, how do I would say your last name? Is it DeCare?
DeCare, yes, Your Honor.
The lawyer is
Mr. DeCare, thank you for your help. You're free to leave the Zoom call. And Ms. Bowden, you and Ms. Gashira can, Mr. Gashira can as well.
Thank you.
Thank you.
Interesting shirt for court.
Ms. Kamari. And Mr. Swenson.
Mrs. Lee, Mr. Swenson.
Was the tablet set up, Your Honor? The Surface?
That's not a promising. I believe so. Was it?
Yeah.
You're
Yes.
supposed to have a breakout room.
Because I don't know. Did Ms. Kamiri already get a breakout room with?
Without
We are done.
I think she.
Okay, sorry. Good morning.
Yeah,
Your
Ms.
Honor.
Ms. Kamari, could you come on the Zoom call, please, so we can take Ms. Parlett?
And I don't know, Your Honor, while that's going on, if the Spanish interpreter.
예, 미스 팔렛 앞으로 나오시죠.
Ms. Kamari?
Yes, Your Honor. I don't have the update on the evaluation, so just requesting a reset till August.
예, 지금 평가가 없기 때문에 8월 달까지 연기해 주십시오.
Do you understand that, Ms. Parlett?
이해하시겠습니까? 이해하시겠습니까?
And she nodded yes. Is your mailing address still on 90th Street in Tacoma?
주소가 90가 타코마 맞습니까?
Not Tacoma, Lacey.
It's not Tacoma, it's in Lacey.
You're right. Wrong. I was looking at the wrong one.
예, 딴 거 잘못 보셨습니다, 판사님이.
You live on Illinois Lane in Lacey.
Yes, Lacey.
일리노이 레인 레이스가 맞죠?
Okay. We're going to give you a court date right now.
지금 다음에 법정 날짜를 드리겠습니다.
Once you get that, you may go.
그거 받고 난 다음에 이제 가셔도 됩니다.
뭐 언제 오라는지 그걸.
예, 종이 드릴게요. 종이 드리게 기다리십시오.
예.
예, 저 여자분이 갖다 드리겠습니다. 기다리십시오.
Did Mr. P be able to get a hold of you, Ms. Kamari?
Yes, Your Honor. I have him on the phone right now.
Okay. Because he said he had trouble for a bit.
Yeah, he was calling while I was speaking with Ms. Parlett.
Yeah, I'm just looking at the time here. I wonder if Mr. Swenson needs a breakout room with Ms. Alamada and either of the people in the courtroom.
Yep. So
this court is always crazy.
이제 가셔도 됩니다. 종이 받으셨으면 가십시오.
감사합니다.
Thank you. Thank you, Your Honor.
You're welcome.
So may I leave, Your Honor?
Do you want to go in with the tablet and then? Yes, Ms. Lee. Sorry about that.
No,
That's our
okay.
only interpreter
All right,
case. You may
thank
go.
Your Honor. Okay, bye.
And I am aware of the time, Your Honor. I'll be quick.
Yeah, we got some time. We got about 20 minutes yet.
Thank you.
So do you want to, Ms. Ahmadi, you can go into the breakout room and then take one of them with you. And Mr. Swenson, are you speaking with both Mr. Hernandez and Ms. Moreno Ramirez?
Who's the guy wandering back behind
Okay.
Mr. Swenson?
So it'll be, Candace is going to put you in the breakout room right now.
It's like his teenage son wandering
Is
through.
Mr. Mercado Henriquez not present?
I don't see, no, he is not present.
Okay, if there's no issue from defense, city's requesting a $1,500 warrant on that one. He has prior warrant this case.
Warrant will issue. So the only three left, we have Mr. Hernandez, Ms. Moreno Ramirez, and Mr. Peak. There's this back, Janice.
All right.
There's this also.
I think we sort of caught up with everything there. We sort of jumped in unceremoniously to that one. But we're going to bail in a similar manner, just do an Irish goodbye. Why? Because I want to see what Judge Simpson's doing right now. Somebody said he's having a fun day as well. Judge Simpson, what are you up to? Let's do a quick check.
Would be the ramifications if she doesn't change her story.
Your Honor, that's something for the court.
No. I'm saying as between the two of them, what would be the ramifications of her not changing her story?
Well, Your Honor, technically she did change her story. She called up here.
Okay.
So you know, if we're going by the police report, correct. The ramifications of her not changing her story is detrimental. But but if we're going off of her statement after this alleged,
did cross and defense change sides here?
What I hear you saying is that, and all of these are very different in terms
We're going to
of
back
what
this
is
up just
said.
a little bit. We're going to back it up. Let's see. White jacket. Do we have to go all? Is this like an hour-long hearing?
Ms. Burks, I thought there might have been a double payment, and that's why I wanted the public defender's office to contact the insurance company. With that and what Ms. Harris has indicated, it now, while it seems an awkward way for the things to happen, it makes sense now. That's why they particularly got rid of that other case. Not because they had paid Ms. Harris, but
that's a different case. I went too far back. Let's see. Is this?
But she's been helping me a great deal.
She says,
I think it's this one here.
Hi, Jeff.
Oh, your name?
Rachel Landry.
All right.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Landry. I just want to put on the record, Judge, I believe my office represented Ms. Landry on the original case. We did not assist her with the expungement. We were listed as counsel on the expungement, but we did not file that on her behalf. So I just want to place on the record that.
Did you file it on your own?
Legal services.
One step, was it?
I'm not sure. It's called legal services.
All right. And you wish to go ahead with
Yes.
this set aside. Okay. And you've seen your application to set aside the conviction?
Yes.
And anything you want to tell me?
No, but the victim's here in case you want to ask her, because she's my mom and she's very much for me getting my record set aside.
She's here?
Yeah, my mom.
Did you can come up, ma'am, if you want to.
Judge is really nice.
That's okay. We'll wait. No, they'll be good. I think they were here together.
Have to keep going forward.
Hi, Your Honor.
Hello. What's your name?
Judge is being really nice to them. We'll go forward through this one. Did he call another case right here?
It depends on what day it is, right? Okay. Was I nice at least?
Yes.
Oh, okay. All right.
Yeah. Very nice.
Young lady, and I will be passing along to Judge Valvo's already.
Yes.
Saw you because she likes to hear that,
Yes.
certainly, and
thank you, Your Honor.
see the success stories and the like. And again, it's nothing, nothing like, I guess, having your mother be able to come up and say kind words about you and what you're doing with your life. And for the court, that means a great deal.
Thank you.
An opportunity having been given for the Attorney General and prosecuting attorney to contest the application and having no objection to it. Court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the conviction. And the court does believe that it would be consistent with public welfare and justice. Therefore, these convictions are hereby ordered set aside.
Nice. Clear the record.
Thank you. Thank you.
You guys take care of each other, please.
Thank you.
And if you want a copy of the order doing that, you can pick it up front at the front counter.
Okay, thank you, Judge.
All right, take care. Court does call the case of the People versus Elizabeth Dixon.
Is this the right one? Elizabeth Dixon? I heard it gets a
Good
little
afternoon,
spicy.
Assistant Public Defender Lauren Perny on behalf of Ms. Dixon. Can you please state your name for the record? Elizabeth Dixon. Your Honor, today is the date and time scheduled for an expungement hearing. We did receive a letter from the AG saying that they believe Ms. Dixon is eligible for expungement of this conviction. And I do have a statement of what she's been doing and why she wants this.
That may not be necessary, although I'd like to hear it. And the reason I would say that is
defendant in the green jumpsuit.
When we looked at this case is not on the defendant's criminal history, which means it is likely that this case was a part of the automatic set-asides that happened, and therefore this expungement would not be necessary.
It's already gone. There you go. Okay, I'm looking for somebody in green. Defendant in green. That's him. This is the one. He's got a little sidebar that concludes here. Mics are off for this part. Josh, thanks for the heads up about this one. I can't wait to see what it's about. Nice rubber band there. Gonna flip somebody with it.
So he's in an attorney netherworld.
What?
No, I know, but
he's an attorney in another world. They're bringing in the defendant. He's the guy in green.
Court calls the case, people, State of Michigan versus Michael Kyle.
Assistant Prosecuting Attorney Morgan Gross on behalf of the people.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Kyle, who appears to my left. Mr. Kyle, can you state your name for the record, please?
Michael Kyle. All right, he can have a seat because.
Okay, thank you, Your Honor.
All right. May go ahead, Mr. Gross.
Your Honor, I primarily am going to be relying on the motion. I do just want to note, after having received and reviewed defense's response, there seems to be two focuses there. One, that Mr. Kyle did not engage in any actual wrongdoing, and two, that any potential wrongdoing that may or may not have happened did not actually lead to the victim failing to appear. There was one statement in the first call where the grandmother had patched in the victim, where she said specifically, I know, and I still don't think there's a reason to put your hands on somebody though. And Mr. Kyle responds back, I didn't put my hands on you like that. And if I did, I apologize. To me, this is really the heart of the issue, is that he is persistent and consistent in telling her that she needs to call and tell them that nothing happened and that he didn't choke her. And this is the statement where she says, no matter what, that's not a reason to put your hands on somebody. And he says, I didn't. And if I did, I'm sorry. That's the heart of this. And if we're talking about wrongdoing, the content of this call is a continuation of the wrongdoing that we see in the initial incident, where he takes the phone from the victim and keeps her from calling 911 to call his grandmother, where she tells him not to call. She tells the victim not to call 911. This is a pattern of behavior that we're seeing continue on after his arrest and arraignment.
But isn't there even a more concrete statement where there's an indication where the defendant is talking to the grandmother about communicating to the victim to change her story?
Correct. And I think that that goes beyond the direct contact with the defendant and the victim, and it relates to ongoing contact that has continued outside of the jail between the defendant's family and the victim. She is so in fear that she did not appear for preliminary exam, and I am concerned that she won't appear again, which is why we filed this motion, because of the defendant's persistence and pattern of behavior exhibited in the initial incident and then continuing in the calls.
Thank you. Thank you.
Thank you, Your Honor. And thank you for allowing us to have this hearing. My objective today is to show this court that the people cannot establish their burden even by a preponderance of the evidence. Just to clarify what the people have just mentioned on the statement that was just said about regarding putting their hands on someone. Your Honor, we're here for a forfeiture of wrongdoing motion. And if we finish that, the context of that statement, he also said, I did not, and if I did. So I just wanted to put that before I forget. I believe all three elements are in our favor, and I will use the standards set forth in.
Even if done through a third party?
Your Honor, I will address that.
No, you will address what I ask you to address, even if through a third party?
Even if through a third party, the elements?
If there's a statement made by the defendant to a relative, I believe a grandmother in this case, or his mother, indicating between the two of them to tell the victim to change her story. And then an acknowledgement that somebody will. Why isn't that a wrongdoing?
Your Honor, that will go towards the clarity, the intent, and the purpose behind why to change her statement. And I was going to go through this element by element, and that question, the best response to that question is, if you go through the jail calls, which I'm sure you have, if you go through the jail calls, there is, I'll just go through them now. In the jail call on March 26, 2024, in the motions at 8:25:55, Mr. Kyle called his grandmother, right, and Miss Lazarski. And if you look at the jail call at 3:05 into the jail call, so did you tell them I choked you? This is a question towards the complaining witness. Miss Lazarski stated, I didn't say anything to them. Okay, at this point, there's confusion. There's mixed testimony that we are trying to clear up. Mr. Kyle then followed, can you call up there and change your statement? Can you call up there and change your statement because they are saying that. They are saying that. Then she responds, I'll call them and talk to them. So her intent is clear. Okay, and then grandma responds, they hear everything on this phone. So they are, and when you make phone calls from jail, we all know, it says this is a recorded line. Mr. Kyle responds that it's not about them. They told me, you said that I choked you. They're telling me that you're saying I choked you. She responds, again, I'll call up there and talk to them. Mr. Kyle says, is that what you're trying to do? Question. Or do you just want me to leave you alone? Question. I get out, is that what it is? 4 questions. Answer to that question is, Your Honor, he's not calling his grandma to say, oh, fix her statement because she, her statement is concrete. Because what Miss Lazarski is telling him is she's saying this never happened. I never told them any of this. So, and I highlighted in another call. On March 26th, the day before the arraignment, at 18:39:58, at 9 minutes and 47 seconds into that call, Mr. Kyle asks her, "You said you had said what?" And Ms. Lazarski replied, that it's not how it went, and that I wasn't, and I didn't say any of that, and that I didn't want to press charges or move forward. Mr. Kyle replied, and I love that. Mr. Kyle replied, I mean, if that's how you feel, then of course go along with it. But you know, when I talk to you, here we go, it's completely different from what they are saying. So
how is this not tampering?
That is my response to that.
Why wouldn't that manifest an intent of some type? I mean, if what you're indicating to me is I'm supposed to garner some intent, that it has to be something direct. I mean, why is he involved at all in the changing of what allegedly is said? Why is he doing that at all?
That's a great question, Your Honor.
It is.
And thank you for bringing that up. And the response to that would be, Mr. Kyle is facing potential felony charges. He's not been arraigned yet. He wants to know exactly what's going on with what the police report saying, what the complaining witness is saying. Again, the no contact is not set in place. So Mr. Kyle's liberty is at stake. So I don't see it to be unreasonable for a situation like what Mr. Kyle and the complaining witness have gone through allegedly, for Mr. Kyle to call immediately on the mother of his child, the complaining witness, to clarify what is going on.
But he goes beyond just what is going on, doesn't he?
I respectfully disagree, Your Honor. I don't think it goes beyond what is going on.
He calls her and says, well, what's going on? This is what I hear. This is what you hear. Okay. But he does more than that. Doesn't he?
Your Honor, if I may.
Yes, go ahead.
He goes beyond asking for clarification. He makes explicit statements. He says to his grandmother, can you call her? I need her to change her statement. That's not a, can you ask her what happened? Can you ask her how she felt? Can you tell me what is going on? He says, can you call her though and tell her I'm on the phone so she can change my statement and I don't have to go through with felonies? Because I'm not even going to get out of jail until tomorrow. That's not a, can you tell me more? Or what's going on? I'm confused. That is explicit and direct and with intention. And it is exceedingly clear that this is a manipulation of the victim.
If that's how you feel, then go along with it. You are telling me you did not say any of that. So this isn't a, oh, well, go up to, let me call grandma and tell her to fix the statement. Fix your statement in regards to the truth is what's going on. If you are telling me you did not say that, but the police are saying you said that, then just tell the truth.
Counsel, but your argument, the court would never, well, would rarely be able to find that there's any intent to do anything other than try to clarify. I mean, because I mean, it seems to me the argument you're making is that it can't be the context or the sort of totality of all that's being said into maybe said to various parties regarding this to express some intent of the defendant regarding this particular case. But that as I hear your argument, it almost has to be some express statement on his part.
Your Honor,
the court to find that there's intent.
Your Honor, I believe, if I may, I'm sorry.
Go ahead.
I believe there needs to be, and I've sat in on a motion, forfeiture motion hearing in this honorable court just last week, and I loved the court's analysis because it took the context of the call, of that jail call, and obviously this is completely different facts, different circumstances, but the court in its analysis almost made a spectrum of the context of the jail calls. It was the spectrum almost being don't show up, and if so, lie. And this was another case, not has to do with this. This case here that we're here for, I believe, is almost opposite of that. And that don't show up and lie is egregious. It's undue influence. It's manipulation. It's obstruction. It's pressure.
But what would be the ramifications if she doesn't change her story?
Your Honor, that's something for the court.
No. I'm saying it's between the two of them. What would be the ramifications of her not changing her story?
Then it means.
Well, Your Honor, technically she did change her story. She called up here.
Okay.
So if we're going by the police report, correct. The ramifications of her not changing her story is detrimental. But but if we're going off of her statement after this alleged.
Counsel, what I hear you saying is that, and all of these are very different in terms of what is said, is that somehow or another it has to be so direct that there can't be sort of this manifest, one couldn't conclude that there's some intent to not have this person testify or to have them even testify falsely.
Your Honor, I believe it's the intent for the complaining witness not to testify, or if to testify falsely, or make the complaining witness unavailable whatsoever to the court. Ms. Lazarski, the complaining witness, has, I don't know how much clearer she could make it, she could state it in the jail calls. I don't. I
mean, what he wants is he wants it to go away. He doesn't want to face the felony charges. He says that, right?
And that's...
Well, no, that's what he says, right?
Of course, yes.
And then says in essence, you need to change your story so that doesn't happen, right?
I don't know.
Well, what do you know? I mean, what do you mean you don't know?
No, I'm not saying I don't agree with that, Your Honor.
What do you think he's saying then?
What I'm saying is he is trying to have her testify to the truth. If she is telling, Your Honor, if somebody's telling me something.
Then why even bring up the felony charges?
Because he's facing felonies, Your Honor.
But he says, I don't want to face the felony charge. I don't want to be here on a felony. Why do you think he says that?
Your Honor, that's what I'm sure many people would say.
Why do you think this defendant said that in the context of what else he was saying.
Because he's saying this because she is telling him that is not what went down. That is not what is said. So why are they saying, why does the police report say that it does say this? Because now I'm facing felony charges.
Is that really what you think he said?
Careful.
Your Honor, if
Careful,
I may,
counsel.
it's not just I want these felony charges to go away. It's beyond that. It's if they don't go away, I'm going to be here for a really long time. I'm not going to be able to talk to you or our kid. I'm not going to be able to be around. It's holding over not just the bad, but also the good. But then you have in the back of the victim's mind the fact that she just got strangled. And so you're dangling a carrot and the potential of the negative as well. And he's very explicit about the potential consequences. I'm looking at felonies. If you don't change your story, you want me to leave you alone? Or they probably won't find out. Like, I'm gonna have to stay in here until my court date. It could be weeks, months, however long. And
trying to duck
if we're
some
talking
felonies.
about him wanting to get to the truth, when she says explicitly, I still don't think there's a reason to put your hands on somebody, that is a candid statement that she made. And he discounts that. He immediately says no. She tells him the truth. He makes an unsolicited, excited utterance that he put his hands on her, and he immediately brushes that aside because it's not what he wanted to hear in that moment. It's not what he wanted to have said on the recorded line. And when he's faced with the truth, he goes right back down the line of dangling the carrot. If you change your story, I'm going to get out soon, not in weeks, months, however long. Can you please do that and let them know that I never put my hands on you?
Mr. Rancer?
Yes, Your Honor.
You talked about this spectrum that the court had brought up in the other.
Yes.
Why are you saying this one falls closer to the other end?
Your Honor, I'm saying that because he's not, to my knowledge, he has not said one time, don't show up to court. Okay. Then.
But it doesn't always come through that way.
Okay, that's correct, Your Honor. That's correct. Also, he's telling her to testify to what the truth is. Your Honor,
he's telling her to change her story and say that, right?
Your Honor, she is saying that is not how it went.
He's defending what's almost an indefensible position.
And quote unquote, this is her saying this. I didn't say any of that.
What do you expect her to say?
The truth to a police officer?
No, to him. What do you expect her to say?
Your Honor, this is the same complaining witness who is putting money on his phone to tell him, call me. This is the same complaining witness saying, I love you,
Judge has seen this
back
before.
and forth. This is the same complaining witness that he shares a child with. I don't want any of this. These statements are vital to show exactly why she called the police to say she wants the charges dropped, why she didn't show up to the preliminary exam, and why she will not show up on the 21st. Because I don't want any of this. That's all I'm trying to show the court.
Why she will not show up?
This is as clear as, this is her own words. And it's in the jail.
I don't want any of this. And so none of that you're indicating to the court is prompted by the defendant's contact with her, the defendant's insistence to his mother or to the grandma that you need to contact her to change her story. None of that has any bearing on her whatsoever, Mr. Rinser?
How can we say it does against him?
How can you say it doesn't? I mean, if, and I realize that it's by a preponderance of the evidence, but what I've got is I've got someone who makes a statement about putting your hands on someone, right? Then all of a sudden, I confront you with what they say you said. She basically is saying she doesn't want any of this. Well, that would be true for a lot of domestic violence victims, that they don't want any of it. They probably don't want a whole lot of things.
And that I didn't say any of it too, Your Honor.
Right. What's she supposed to say, Mr. Mansour? Why? See, this is part of the problem here, is your client should have been contacted here in the first place. Shouldn't have been contacted here in the first place, and shouldn't have been trying to contact through third parties to then tell third parties to tell her something. And now, when confronted with it, and he's smart enough to realize, I'm not going to say those things like don't show up, don't whatever. That's why the court has to listen to the context of everything that's going on that the court has to determine whether or not there's some intent on this defendant to stop this victim from testifying. So while you might draw that one conclusion, isn't it equally plausible that the opposite conclusion has to be drawn?
Of course, absolutely. Absolutely, Your Honor. But I'm trying to persuade or show this court that it's not, you know, and if we look at People versus Burns, if we look at the fact pattern there, the facts in that fact pattern, the defendant tells the complaining witness not to tell, don't tell anyone or she will get in trouble. And the court in that case ruled that there was no specific intent for the complaining witness to not be or to be unavailable for court. You know, they were correct on element one. Was it wrongdoing? Yeah, not to tell, don't tell anyone or she will get in trouble. Yes, that's wrong. But you know, they ruled elements 2 and 3, specific intent to not show. It's a case-by-case basis, and it improperly assumes the defendant's knowledge. You know,
that they not show?
Had the defendant intended to have the complaining witness not show.
But your whole argument on those points rest on the exact verbiage outside of context and outside of what may be the reality of what's going on. Does it not?
It's yes, it's case-by-case basis, it's different facts, different things said, different circumstances. Absolutely. You know, I want to point to the court that, you know,
why would he need her to change her story?
Because if the police report,
why not just go up and say, okay, if that's not it, then you need to go to the hearing and you need to tell everybody that. Why not just say that?
Well, Your Honor, this is a fresh matter. He made the calls before his arraignment, wanted to speak with his.
Why the pressure on her, since you don't want to answer that question, why the pressure on her to, through grandma, pressure her to change her story? If I've had a conversation with you regarding you didn't do this, you didn't say this, you didn't do whatever, why am I using a third party to also reinforce that?
Your Honor, I don't know what his phone minutes situation was at the time. I'm not.
What's that mean?
I don't know if he could reach her and find out, check the status on whether she did it or not. I don't know if she has transportation. I don't know if she has he probably doesn't know if she.
That's not my question. My question is, why does he use a third party to also try to exude, at least as the court sees it, that pressure for her to change her story? If, as you portray it, they're having this wonderful conversation and she's saying, no, basically, I didn't say all of that. They've all got it wrong. They've got it this. And that they come to some miracle understanding that she should then contact them to change her story. Why tell a third person they need to basically reinforce that to her? Why do that?
Thank you, Your Honor. Because Mr. Kyle is sitting in jail and has no idea what's going on. And he would like to check the status on whether the statement has been corrected to its truth.
Why didn't we just ask her?
He did, Your Honor.
But so you're not answering my question. Why do I use a third party to do that?
Why call grandma?
If I've had this meeting of the minds that you got it wrong to the police, and so therefore now you're going to make everything better by changing your story. If that's the case, why have somebody else have to reinforce that? If you just need to tell the truth, why do I have to have somebody else call and say?
Yeah, Your Honor, it's a great question, and I will answer.
I'd like a great answer.
And my answer is to check the status on whether she did or not. And
But he didn't ask the person, check on whether or not she did.
Your Honor, I believe in one of the jail calls, did you talk to Rachel? Did she manage to go up there along, I'm paraphrasing this, but.
She needs to change her story. Operative words.
Not because
you need to tell her to change her story, basically.
Because if she does not.
Is that really checking on status, counsel?
Your Honor, also.
Is that really checking on status?
I can't tell you exactly why.
That's your argument. Your argument to me is that he's checking on the status. Is that checking on the status to you?
It can be, Your Honor, if he's.
Seriously? That's checking on status?
Did you talk to Rachel?
Go ahead with the rest of your argument.
But I'm
done in regards to that as well, his grandma, his mother, all are in communications with Rachel. They, in regards to their child, they've said it many times in the jail calls. We're calling to check up on the child, And there was statements in a lot of those jail calls where the mother herself, this is between you guys. All I care about is the baby. So, I mean, I'm sorry, I can't give you a pinpoint answer on why he called the grandma to see the status to ask if she's talked to Rachel, but those are the circumstances.
Are you done? Judge is not impressed. I don't think you won him over. Phone privileges
Your
revoked.
Honor, I just want to
address Bond
on the fact that the language, the demeanor, and the motive behind those jail calls, or in context of those jail calls, was not to procure unavailability. Because not once did he say, don't show up. Not once did he say, lie. Okay, the motive was to correctly testify. So I don't believe any of these elements are met. None of the three, due to those reasons. You know, if he was telling her, hey, you got to go up there and tell him I didn't do any of that. Tell him make something up, lie, don't show up. No. The jail calls, what did you say when you got up there? That I didn't do anything. Okay.
So you really think it has to be that direct?
It's by a preponderance of the evidence.
No, but do you think the examples that you give are certainly the most egregious of circumstances? My question to you is, are you indicating to the court that it always has to be that direct? That there can't be context to what's being said?
Your Honor, that is exactly what I'm saying. In our favor, though, the context of those statements, does it have to be that direct? No, it could be many different ways. You know, we look at People versus Jones. People versus Jones, in that case, there was the facts were the defendant was involved in a gang, and the complaining witness didn't testify because of the repercussions of testifying in a gang. Or People versus Giles, where the defendant made the complaining witness unavailable. The complaining witness she's available. She's available. She just does not want to proceed. She does not want to move forward. She said it. So no, it's not that direct. There's context to it. It's case by case basis. And if you look at everything that is going on, I don't know. I don't know where he said don't show up. I don't know where he said don't lie.
Hang on, counsel. That's precisely what I'm asking you. You keep coming back to that. And I'm asking, does it have to be that direct? You tell me it doesn't have to be, and then you proceed to argue that. So I'm unclear where you're coming from. Well, my question to you is, there are ways of telling people not to show up or placing them in a difficult position where they don't, which would be tantamount to saying don't show up. By way of example, if the court draws the conclusion that he's asking her to change the story, that she then tries to change the story, but it doesn't change the posture of the people in proceeding, she's now caught. Because now she has to show up and lie or just not show up at all. And you don't think that one, through that series of events, could reasonably draw that that's what the defendant's intent was? That if it works, it's gone. I'm out. But if it doesn't work and they don't get rid of it, then you got to lie or you got to do whatever. I placed you into an impossible circumstance. Why wouldn't that be tantamount to causing the unavailability of the complainant and have reasonably been what he desired to occur?
Your Honor, could it not be her own choice to not show up? Could it not be the fact that she does not want to proceed on this. And it could also be due to the fact that what was said was out of context. There was no indication of.
If her choice is a voluntary one, then maybe. The problem that you have is you've got all of this, which would lead the court to the conclusion that if she doesn't show, that's not voluntary on her part.
Your Honor, the court here has revoked Mr. Kyle's phone privileges.
Because he violated bond.
That's, yes. We're not objecting to that, Your Honor.
Well, you can object all you want. He violated bond.
You're 100% right.
I know. Okay. So what's the point of this?
Your Honor, his phone privileges were revoked on the 6th of April. The preliminary exam was on the 21st. She has had all that time, almost 2 weeks, with no contact. Nobody's spoken to her to make the decision.
Oh, no. That's not true.
You're right.
I know that's absolutely untrue. His contact comes through a third party.
All right, Judge, I think we've heard enough.
Your Honor, I misspoke on that. I meant to say Mr. Kyle did not make any phone calls, obviously, because his phone privileges were revoked. However, Your Honor, I've said all I've needed to say in purposes of this argument, and I appreciate you taking the time and this court to allow me to make those arguments.
Thank you. Anything else from the people?
Anything?
Nothing further.
Court in reviewing that and listen to the phone calls and giving context to those phone calls. The standard here being a preponderance of the evidence. The court is of the opinion that the context made to, let me say that, it would be, I guess, easier if defendants were just saying to victims, alleged victims, don't show up, don't testify, don't do that. If they use those exact words, these become simple analysis. So that would be easy. Or, if quite frankly, defendants would abide by the bond condition of no contact, then that would be easy, because then if they don't show up, it has nothing to do with, or would not possibly have anything to do with what the defendant did. But none of these, or very few of them, I should say, are that direct. They go through other mechanisms by which to have the victims either not appear or change their story or in some way attempt to try to cause their unavailability. Clearly, his contact and the statements made are wrongdoing on his part. The court believes by a preponderance of the evidence that the statements made, the context upon which they're made, the further contact with the grandmother directed to say things or continue to say things to reinforce things to this alleged victim, the court does believe that by preponderance of the evidence that was specifically intended to procure either her false testimony or her unavailability, should that not, or could she not stomach making the false, what may be considered false claims or changed claims. The question as to whether or not is engaging in that wrongdoing, and then whether or not it has caused, will cause the unavailability of this victim. It already has on one instance, and or caused her to take a course that it did. It may indeed on the May 21st cause that to happen. It certainly did on April 23rd. This court's belief is, having listened to everything. And so for those reasons, the court would grant the people's motion, and that the statements, if they are otherwise admissible under the Michigan court rules regarding evidence of the alleged acts of domestic violence, will be admitted through the
police report.
Proper witness, that typically being a police officer. So people's motion is granted.
There you go.
Thank you.
Thank you.
Okay, so let me explain what just happened here. Because that lawyer just lost big time. He made a nice argument, but then I'll answer Psychosaurus Rex question. In that whole thing was basically the defendant reached out to the witness, the one who was the victim in the domestic violence, asking her to change her story. The wording he used was, "You need to tell the truth, that none of that happened." Judge saw through that and said, "Nope, that I see what that is. I've seen enough of this. That's what," and because of that, because of what you're doing, it has the intent to make the victim not want to participate in the proceedings, to be unavailable for court. Typically, that would mean that the charges are dropped because there's no witness, no testimony against you. It's all dropped. The judge rules that the police report is now admissible as evidence, where normally it would not be because it's hearsay. But because of the actions of this defendant, now that police report is admissible. So, yeah, don't try to go around the back door. That's, yeah. Anyway, okay, quick question from Psychosaurus Rex. Was the BK hearing really canceled? I thought that the 2 week this week would be closed to the public, just not canceled. Yes, Psychosaurus Rex, we went through a couple documents that just got posted just today or so on the Idaho webpage for BK. And the judge ruled that the hearing today, as well as the hearing on the 16th, are going to be combined into a hearing on the 30th. What happened was, this was a motion to compel hearing, and guess what? The state delivered some evidence. They gave them something. They gave them some materials. And so because some materials were handed over, they said, let's delay it for 2 weeks, and then we'll move, then we'll see what we have to do on the 30th. That hearing also is going to be open to the public, but if it goes into areas that are closed, it's going to be closed. There's another hearing that specifically regarding the IGG that they are going to close to the public. But we've added those, if I can tell you, on the calendar. So now the calendar looks like this. Let's see, it's May 14th today. So the May 14th one is gone. May 16th one is gone as well. We now have a hearing motion to compel open to the public on May 30th at 1:30. I believe 1:30. It might be 10 o'clock. I might not have changed the time. I'm not sure what time that one is at. I think it's 10 a.m. Then there's a possible hearing on May 31st. The judge has reserved the date if they need it. Then in June, we'll see, May 31st, also the deadline for briefs about the change of venue from the defense. May 14th, the state has the deadline to respond to those briefings. June That's June 14th. June 20th, a reply by the defense to the state's response. And then finally, June 27th is a full-day venue hearing where they actually decide on the change of venue. So that's where we're at on that one. Let's see. Will the trial ever happen? Yes, it will. If you got to use grandma to convince a victim to change their story, it's over. You should have just let it play out. Many DV victims recant on their own if they're going to. They can. I think he already had been told not to contact him. That's where the problem was. He made the contact anyway. And so the judge, yeah, no bueno. May 30th, is it 1:30? Okay. I'll keep 1:30 in there. Britta, thank you very much. Good to see you. Well, have a good night. Let's see, anything else to go over? There was a little bit in Corey Richens that happened the other day. Let's see. Don't think that one is as juicy as what's going to happen tomorrow with Corey Richens. So we're looking forward to that one. That's where we have a pretrial hearing. Hopefully get a date scheduled from that one. Anything else to talk about today that's going on? What are you guys seeing in your world of true crime? Megan Easton, member for 12 months. That's a whole year by my count. Megan, congratulations. Thank you for this incredible community, RA. I adore every one of you. Thank you, Megan. Appreciate it. Wouldn't be the same here without you. Congratulations on 12 months. Corey Richens was short, only 10 minutes, not much to report. I heard she looked terrible. Like jail's not... Jails are rarely good for anybody, right? But some people, it can be really, really difficult. 48. Greeners, you telling the truth? 48 Red Lobsters are closing? I just went there last night. That alone should keep them going for a little while. Are you just kidding me? Are you pulling my leg? I haven't been to Red Lobster in probably about 8 years because that's how long it takes to save up to go the next time. Red Lobster abruptly closes at least 50 restaurants, including 14 in New York and New Jersey. 56-year-old restaurant chain considers filing for bankruptcy due to rising costs. I have the not Midas touch. What other restaurant would you like me to shut down? I can go visit and have them go under. I tell you, I thought my tip was fair. The service was a little bit poor. I say the service is poor because I only have my service. I judge my service based on what I see other people getting at the same store, right? So I realize there can be nights where it's just, everything's gone wrong in the back room, in the kitchen. I realize those happen. And I like to give people a little leeway on there. But when I show up and we're like ready to order, as soon as we sit down, we're ready, okay? And our waiter takes forever to come around, forever. And then finally comes around and gets us our drinks, which, we did water because then we could afford it. And then... and got us, I think we got some cheesy, whatever, the mozzarella sticks. And in the time that happened, another group came in, was seated, was greeted, was given their drinks, and they got their appetizer and their meal. I just felt like they were ignoring us a little bit. And so it was a little bit slow, and I think it was because I had the all-you-can-eat shrimp, and they wanted it to like let it sit in his stomach for a while, let it fill him up for a bit before we give him another plate. and it took forever to get the next round of shrimp, which I did 3 rounds of shrimp. It's because they ordered booze, Ivan. Oh, man. Megan says, first channel I paid for, Recovery Addict. Y'all have been my friends for a whole trip around the sun. Love that for y'all. Megan, thank you very much. It's been wonderful having you here. Congratulations. Here's to many more. One place keeps failing near me is KFC. They still have not remodeled for over 2 decades. The grease alone is what's holding everything together. Jim Bob, believe it or not, I actually like KFC. And I think the grease is the secret recipe. You know, they use the original grease to cook the chicken. That's where the flavor's at. I worked at Red Lobster in college. If you order an all-you-can-eat, they're supposed to fill you up on Cheddar Bay biscuits. They did bring us those, that's for sure. But I told the waiter, all you got to do is just keep the shrimp coming. He's like, okay, I will. And it was probably 20 minutes between rounds. All right, why are we talking about food? We just had lunch. Original recipe with the original grease. Oh no, instinctively correct. I'm so sorry. Let's see. Acquiring the KFC coleslaw and gravy recipe is a bucket list item for me. That brown gravy is delicious. Good brown gravy. Although when it gets cold, it's the worst gravy ever. Some gravies are okay when they cool. Not that one. Not that one. It turns into like Jell-O jigglers when it gets cold. During the brief hearing yesterday, Josh says, in front of Judge Mrazik, prosecutors were given permission to admit additional evidence ahead of the preliminary hearing tomorrow at 9 a.m. Let's see. To Brent, catching up on KR, do you think we may catch the Microsoft hearing tomorrow? Samantha, I think I saw that in Mod Chat. We may... I don't know, we're right in the middle of a witness, and she's going to continue, and we get the juicy bit tomorrow. That one word, that comes out tomorrow. We'll see. Let me think it over, Samantha. I like that idea, but just know we only have 2 days of Karen Reed next week. 2 days of trial, and then 3 days off. So we're going to have to have something there. I wonder maybe if we go back and watch Microsoft hearing then. That might also be an option. I made $1,000 off GameStop today. HODL, right? That's the key word, HODL. Thought Sarah Boone's trial was supposed to start yesterday. Ray, it was supposed to start yesterday, but then she wasn't ready, or her team wasn't ready either. So it's been pushed out again. And I sold it. I've got some options. First of all, let me say, I do not recommend trading options to anybody, okay? Because they're extremely risky. And I have consistently lost a lot of money trading options. But let's see. No, I don't want a credit card. Let's see. Man. I've got some options on a little company that I think is going to go up, 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 up. And they're dated for August. And I think it's gonna cash me in. If I did cash in on these options, I would have enough money to go to the Red Lobster again. It's not like it's going to make me rich or anything. All right. Daybell is on a break, or are they done? Oh, they're on a break. Options, Russian roulette, but baby, when they hit. Oh. You're buying the meme stocks, Lenovo. Are you sure your Red Lobster isn't the one that's just closed? It might be. I'll have to swing by and see if they're still open. And if they did close, good riddance. It's because they shorted me on the shrimp. my opinion, Red Lobster deserves whatever it gets. They were way, way, way overcharging even 20 plus years ago. I saw they had a bunch of lobsters in the tank. So if they did close, those lobsters need a new home. Somebody needs to rehome those lobsters or let them free. Let's see. The Karen Reed trial has switched from the What If Any trial to the I Don't Recall trial. Got a lot of that from some of these witnesses. USA Today has a list of closing by state. Are there any in Greenville, North Carolina that closed? It would be crazy if I went there the last day that they were open. Those lobsters just live in that tank. They just live there. That's home. Nobody actually eats them. None in North Carolina. See, I'm good. My oldest son is lobster fishing. Okay. Let's see. All right, I think, let me see if there's anything else we needed to check out. I don't think there is. See, it's Tuesday today. 2 more days to the podcast. Still waiting for my replay keyboard. And I have to buy the software now. I thought the software was going to be free, but the only way I can show, I'm not sure if I can show this one. Let's see. Where's my mouse? Oh, this one. Let's drag this over there. Okay, so if I go to channel 8 here, this is my replay software, right? So I've got all the different court feeds that have been playing. And like we can watch this little guy from before, and you can see that there's a cat that jumps across his screen. If we hit play right here, it'll do this. At least in theory. Where's the cat? Oh, now he's frozen. Oh, there's the cat. Let me go back. Rewind. Seeing if I can see the cat right there. There's the cat. Right there. The cat came down and jumped on his keyboard or something. It looks sort of like a dog there. But the long tail is the giveaway. And the jumps across his screen. Anyway, so I'm not sure why I'm showing you that. I thought that was funny. Jay Hatch hearing on August 1st. I'm not planning on being there on that one because I'll be in another state. I think I'm going to be out west for that. All of August and some of September. Corey Richards does have a pretrial hearing tomorrow. Starts early in the morning, so for us it's going to be about 10 or 11. My goat looks like a tauntaun right here. They closed my hometown Red Lobster overnight. No notice. Man. It's a bummer deal. It is for the wedding. Yes, I'm going there for the wedding. And we're also just going to visit family, and we haven't been there in 5 years. There's family I haven't seen in 5 years, so I thought that would be cool just to, poke my head in. I think that's all. So tomorrow we're going to have a full day of Karen Reed. I think that's the plan, Samantha. I think we might wait on the Microsoft one. Let me read up and see what's going to happen. We'll see what happens. But tomorrow we'll have a full day of Karen Reed unless we change our mind and do Microsoft. Are you sure the statute of limitations run out before you head back? I probably should just do a quick little warrant check to see if they have just anything outstanding on, parking tickets or something like that. They might pick me up at the airport when I land. Oh, the spice in Karen Reed. It's so good. There's lots of spice, and it's coming in by the bucketful right now. Check courtroom 4, Finks Court. looking. Court 1, 2, 3, 4. District Court jury trial motion in limine. Thurston County. Is that the one you're talking about? Maybe done. Okay. I see some stuff from yesterday. That's all. All right. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning about 8:45. It's gonna be great. Thank you to our wonderful mods. Thank you. I haven't heard if George Kelly's with Prejudice or not. We'll have to listen to that one. Thank you guys. Have a good night. Be good to each other. We'll see you. Bye-bye. Wrong button.
I'm not a cat.